Robin, are you there?
Yes, I am here.
Hey, this is Justice Hood.
Hi, how are you?
Good. I'm marveling at the fact that I'm actually communicating with you right now.
Yes, and your name is showing up on my screen, and we're looking good. So it looks like we may have a few other people on as well.
How many participants are we anticipating?
About 50.
Oh, cool.
Yeah, we had about 70 express interest and about 50 actually register.
All right, and so you say you can see me right now?
I can see your name as we talk.
Yeah.
Yeah.
Is that the way it works?
Yep.
There are no video images. It's all audio?
It's all audio and computer screen, but no actual video.
Oh, I see. Okay. That's probably better, huh?
Yeah, I'm not much on computer video, webcam type stuff. It always makes people look really funny anyway.
Right. Okay. All right, so I'll just wait for 1 o'clock, and I guess we'll roll then. Good. Thanks.
Yep. Sure.
Yeah. And I guess what I can do is I'll flip it around and we can both just do it on the other screen. They'll have slides. Yeah. They won't be able to see us. They'll just be able to hear us. And then we shut those doors. But we've still got about 10 minutes. Yeah.
Okay.
Can anyone hear me?
Yes, I can hear you.
Hi, Adam.
Hi, is that Robin?
Yep, Robin and Cass and Justice Hood are on the line, and a few attendees as well.
Great. Hello to everybody.
Adam, you're very echoey.
I know. I wonder why. Is that better?
Yes.
Okay. Is it echoey now?
No.
I think it's because
Sounds
I have
better.
my speakers on. How does it sound now, Robin?
It sounds good, Adam.
Perfect. Sorry. I should be better at this technology.
That's okay. So if you're on your computer talking, the attendees, have a list. They're all muted right now.
Right. So any of the speakers want to mute themselves. Take that one mic. That one.
Yeah.
On the screen? I think that just means they don't hear you.
Hi, this is Aaron.
Hi, Aaron. This is Robin of the Bar Association.
Yeah.
Something is something. All lit up differently now. Giving you competitive would be the fact.
So, Robin, before we start, I have a question.
Okay.
Will this show, will other people be able to see whatever's on my computer?
If I switch it to your computer.
Okay. Well, I don't have anything to show on my computer, so
Okay,
don't
that's fine.
don't switch it.
Yeah, I don't have to turn it over to your computer at all, so
Okay,
it can just
great.
be audio.
Aaron?
Yes.
Hi, this is Justice Hood.
Oh, hi. How you doing?
Good, how are you?
Good.
Am I correct in thinking that you'll talk a little bit about the work of the Managed Means Task Force?
Had not planned to.
Oh, okay. All right. Well, I was going to give them a shout out. I didn't want to steal your thunder there. Haven't you been involved with them?
I'm sorry, was that a question for me?
Yeah, was that, Aaron, you're on the Managed Means Task Force,
Oh.
right?
Justice, this is Aaron. I can, if you're on speakerphone or something, because I can just barely understand what you're saying.
Oh, Robin seemed to be able to hear me pretty clearly earlier. Robin, can you hear me?
Yes, I can.
That's better.
Well, I'm
sorry,
trying
now
to
say it
get a little
again.
bit closer to it.
Okay.
Yeah, I don't have a headset, so I feel like I'm being very futuristic as it is.
Okay. Ask me your question again. I'm sorry.
I'm just wondering about whether you're on the Modest Means Task Force.
I am.
Yeah, that's what I thought. And I just
and I can talk about it, but I didn't know that I was supposed to, but I can if you want me to.
Well, I was just going to make reference to the toolkit. It seems that that's a good resource for them to know about.
Do you want me to reference it, or do you want to talk about it?
You're welcome to, because you'll be more knowledgeable. I've read it, but I assume you played a role in crafting it. So.
And Your Honor, I also helped on that, so I could answer questions or speak on it if Mr. Clay needs me to.
Oh, is it? And this is Adam?
Yes, Your Honor. I'm sorry.
No, that's okay. I just used my amazing powers of deductive reasoning to come up with that. So, Adam, am I correct in thinking that you're not formally a member of the Modest Means Task Force, but you nonetheless were involved in putting together that toolkit?
Well, I am a member of the Modest Means Task Force. I think Mark Fogg appointed me, and I wrote a few of the chapters.
Oh, I see. So you're both on it. I apologize.
Yeah, no.
All right, well, welcome everybody. I see we've got most of our participants online at this point, as well as all of our speakers. So we'll go ahead and get started. This is Robin at the Bar Association in Denver. Thanks to our speakers for being here. First up, we'll have Justice Will Hood from the Supreme Court saying a few words, and then Adam Espinoza with Attorney Regulation Office, and Aaron Clay out in Delta. He'll be speaking at the end of or towards the end of the program. Just if you have any questions, there's a little chat box, or should be a little chat box over on the right-hand side in that panel from GoToWebinar. If you have questions, feel free to type questions there or email them to me, and I will pass them along. So without further ado, Justice, are you ready to get started?
Sure. Hello, everybody. This is Justice Hood. I am at the Supreme Court, and I've been asked to address two questions, the first of which is, why are limited scope services vital? And the question was originally posed as vital to clients and the court system. I would submit that it's vital not only into the courts, but also vital to lawyers these days. And so, first of all, let me talk about why I believe that it's vital to litigants. The pro se rate, as everybody knows, is just staggering, and I can't see it right now, but Rob, I assume that you're putting up the slides?
Yeah, I am pulling it up as we speak.
Okay. And if we look at, there we go, the party level pro se rate in Colorado for FY 2013, in district court civil cases, excluding tax lien cases and residential foreclosures, we're talking about a party level pro se rate of 40%, 59% in county court civil cases. And the thing that's most remarkable to me is 76% statewide and domestic relations cases. We know, I assume that most of you are familiar with the growth in self-represented litigant centers, the pro se resource centers. We're referring to the people who work in those facilities as Sherlocks. They can help with forms, but they can't provide legal advice. So it's wonderful that they're able to provide some guidance. And with the recent Chief Justice Directive 1301 that was crafted by the Judicial Advisory Council, the Sherlocks have been able to provide a lot more information to litigants, but they still can't do what a lawyer is supposed to do in representing a client and providing legal advice. We all know that Colorado Legal Services is strapped. They have 47 lawyers statewide, down from probably somewhere in the 80s back to 2009. There are a number of reasons why that is that would exceed the scope of our discussion today, but the bottom line is they can't even begin to help the people who are financially eligible for their assistance at up to 125% of the federal poverty rate, which is it's 130 grand for a family of four. There are a lot of people who are well over that 125% line who still can't afford full scope representation, and there's been much effort made by, among others, the Colorado Bar Association through the Modest Means Task Force, of which both Mr. Clay and Mr. Espinoza are members, to try to fill that gap, and I think they'll speak a little bit more about that. But it's unbundling, clearly is a big part of making services available to litigants who otherwise just can't afford full scope service. And there are many people these days who might very well be able to afford full scope service, but are just opting out. They want help with discrete tasks. They don't want to have to pay a lawyer for full scope representation, even if they're capable of footing the bill. So that's why pursuit is being vital to litigants, vital to the courts, obviously, because dockets become unmanageable. I joined the Supreme Court about 2 months ago after spending 7 years as a Denver District Court judge, where I was for the last 2 years in domestic relations, and we would often see things spiral out of control in there. The pro se rate in Denver is probably higher than it is statewide on average. And to give one example, child support, something that should take a few minutes if we have lawyers involved, can take hours. Things become quickly unmanageable as people try to just provide the court with a lot of information, much of which may be extraneous to the actual worksheet exercise. Simple transactions that lawyers could orchestrate result in protracted litigation when lawyers aren't involved. And so I think the courts have an interest in making sure that lawyers are involved even on a limited scope basis to help prevent those kinds of problems. And of course, judges are often wary about crossing the line into advocacy. The Code of Judicial Conduct has been changed in recent years to try and make things more conducive to judges providing some guidance to pro se litigants, but there's still apprehension that courts are obviously going to have when it comes to wading in too much with pro ses. And finally, I would submit that limited scope services are vital to lawyers because of the business opportunity that's present. I think it's the future of legal practice in many ways. And one of the things that has been very interesting to me is to see this, what's been referred to as the toolkit that the Modest Means Task Force has put together. It's more formally denominated as the successful business planning representing the moderate income client. And Mr. Clay and Mr. Espinoza would know the answer to this, but I believe that that's available online through CBA. Am I right about that?
Yes, it is. Specifically, if you're a CBA member, it's free to download. I think it costs $55 or something to get the hard copy. If you're a non-CBA member, you can download it for barely like $119 or something. Just log into the CBA website and type in Moderate Income Toolkit, and it'll bring it right up. It's called Successful Business Planning, Serving the Moderate Income Client. This is Aaron Clay.
And it has a lot of wonderful templates, draft motions, things that will assist you in doing this kind of work. It also has flow charts on steps that you should take to ensure that you're performing limited scope services in a way that comports with ethical requirements. I think it's a fantastic resource, and I commend it to you. So the other question that was put to me is, how is the court supporting limited scope representation? Justice Hobbs, who's been on the court for many years, has extensively promoted unbundling during the past few years. He's been involved in many sessions like this one, no doubt, with Mr. Clay and Mr. Espinoza on other occasions. The Supreme Court has also amended the unbundling rules twice in the last few years. One set of the amendments that most of our listeners would be particularly interested in is amendments to C.R.C.P. 121 that allows lawyers to file a form saying that they're providing unbundled services, and then to file another form to withdraw automatically when they're done. And that change was made in response to some lawyers' concerns that if they provided unbundled services, the trial courts wouldn't let those folks withdraw. And I think that's an understandable source of concern. But the rule change under 121, 1-5 is specifically designed to address that. And, I'm sorry, 1-1, I believe it is. And then more recently, the Supreme Court added Colorado Appellate Rule 5E to provide that unbundling applies to appeals as well. More recently, and this may be something that most of you are not familiar with, but the Chief Justice, Nancy Rice, has formed a super committee, it's really being referred to as, I asked them if they all have capes, but a super committee that's addressing lists of lawyers who may provide representation to moderate income clients. And there are a lot of issues surrounding the court or the state court administrator's office or other entities being involved in drawing up such lists, and they're trying to work through some of those issues. But in the process of doing that, they're also considering including in those lists information about lawyers who will provide unbundling, who will provide limited scope representation. And so we will continue to, we as the court will continue to promote sessions on unbundling, and we'll also try to come up with metrics that allow us to better monitor the growth of limited scope representation. One of the things that I'd like to try to address is the state court administrator's office finding a way to track that so we can see if my suspicion is correct about the growth in this area and how it really constitutes where the future of legal practice may go in a large respect. So with that, one other thing that I thought I'd just mention is I reached out to Jim Coyle, our new regulation counsel. He's filling the role that for many years had been filled by John Gleason over at the Office of Attorney Regulation Counsel. I wondered about whether there have been discipline cases, because I've heard some people express some concern about how this seems like it might be a disciplinary minefield. And his response was very, very few, none that have resulted in discipline, and that the folks who do this kind of work generally are dotting their I's and crossing their T's. The only example that he could think of where unbundling was at issue in a disciplinary case was where someone tried to raise it as a defense, asserting that there had been limited representation on a 35C in criminal post-conviction matter, when other evidence in the case, including the attorney-client agreement, suggested that it wasn't limited scope representation at all. So the good news is that if you do this, as Mr. Clay and Mr. Espinoza are about to discuss with you, I don't think you need to worry about it becoming a disciplinary problem for you, or creating some concern that you might catch a disciplinary case. I think that's extremely unlikely. And so with that, I'll turn it back to Robin and to our other panelists. Thank you very much.
Thanks, Justice Hood. That was great. Some very good information. We will have Adam Espinoza speak next. He's got a presentation to show as well. So Adam, there you go. You're up next.
Okay. Thank you for having me. I will admit this is my first webinar, so if I make some mistakes showing these documents, let me know. Thank you, Justice Hood, for your comments and the introduction, Robin. I think we'll talk a little bit about the ethical considerations involved in limited scope representation or in providing unbundled legal services or discrete task representation, however you choose to call it. Over the years, I've had the opportunity to study this area of law and the opportunity to present to various bar associations across the state concerning limited representation and the ethical considerations surrounding it. Some of you may have seen this presentation before. Feel free to ask questions of Robin or of any of the speakers, I think, if you have any. Oftentimes I feel that these are better interactive than not. I will try to keep my presentation to 40 minutes, and I'll try not to bore you too much on things here, but I am Adam Espinosa. I work for the Office of Attorney Regulation, so I work for Jim Coyle, who Justice Hood just mentioned. Our office receives about 4,000 calls a year, and about 10% of those are cases that result in investigations that we look into, and about 10% of those cases result in formal disciplinary type cases. I can tell you that I've had an opportunity to review the statistics and the cases here in Colorado and throughout the country, and instances of discipline for lawyers engaging in this kind of work are very low. We'll talk about that as we go through. So what is Unbundled Legal Services? This is actually, Unbundled Legal Services is the term for representation that does not include all the standard bundle or items for representation. So typically when you represent a client, you're going to gather facts, you're going to advise the client, you'll research case law, you'll draft correspondence, engage in negotiation, and ultimately represent the client in a hearing. About 20 years ago, lawyers started to recognize that representation can occur with something less than the full bundle. And you saw it first in business law and in contracts and in various other non-courtroom-heavy type of work. As this kind of practice progressed, you're starting to see it more and more in family law practice, landlord-tenant practice, small claims, civil type practice. Some people told me they've seen it in criminal law practice, although I don't know that that's specifically permitted by the rules. So when you unbundle or you provide limited scope representation, you might choose to do one of these things. Perhaps advise the client on a legal matter. Perhaps assist in the drafting or preparation of documents for the client to file on their own. Or perhaps representing the client in court on an emergency motion for modification of visitation or something along those lines. These are all opportunities that are available to practitioners and for clients if they choose to engage in this kind of representation. So this kind of work is not new. In 1996, Chief Judge Connie Peterson in Denver District Court actually wrote an article about unbundling and asked whether this is the way to help with some of the problems with the pro se numbers that were skyrocketing at that time. Subsequently, the Bar Association took an opportunity to. Can everybody see my presentation? Okay?
Yes.
Not hearing anything, I'm assuming you can. So. In 1998, the Colorado Bar Association also undertook a review of this particular type of representation, which really started out by a gentleman in California who really started pushing this idea. But the Bar Association wrote a formal ethics opinion. That's Ethics Opinion 101 in 1998, and they specifically laid out the factors that that would permit the ethical use of unbundled legal services. Subsequently, the court here in our state reacted, I don't know if they reacted necessarily as chose to act and make changes to the rules of professional conduct and also to the rules of civil procedure to encourage and to permit limited representation. And it's important, as Justice Hood said, that these rules have continued to change all the way up until 2013 and 2012, when the court amended other rules to make it even more feasible for attorneys to engage in limited scope representation. Despite these changes in 1998 and 1999, the unbundled legal services were not getting the same kind of uses. As much as we thought that practitioners would use these rules immediately, they didn't. It almost took years before they really started to engage in this kind of limited representation. I'm having some difficulty with my computer here. So why engage in this? Well, Justice Hood hit the nail on the head. There's many reasons. Access to justice being one of the key ones. A system that has set up for the people, but that has barriers preventing those very people from accessing it, is a system that needs needed some change. And so the court looked at those things and made some changes to allow this limited representation, to get the pro se numbers down, to get people into the court, to get the relief that they're seeking. It really is an ongoing process, and as Justice Hood mentioned, that with numbers of up to 72% of all domestic relations cases involving two pro se parties, you have to ask yourself, are we doing all we can to make the rules and to make the process something that all of our citizens can be involved in and the relief and get the relief they're seeking? So you can engage in unbundled legal services as a pro bono type of a thing, and that's really how it started, and trying to encourage pro bono representation to deal with these pro se numbers. Since, though, the court has made it very clear that this can also be for fee-paying clients, especially in this modest means realm, where you might be helping somebody that can afford some legal fees, but not the traditional legal fee that we might see here in the Denver metro area. Now, Justice Hood also dealt with this issue, whether or not you're going to be disciplined or receive a malpractice claim. This is important because as we traveled the state, Justice Hobbs and I, and spoke to every bar association in the state, there were a few that gave us feedback that they thought if they engaged in limited representation, they're more likely to be disciplined and to receive a request for investigation with our office. And that really hasn't panned out. That really is not what we found. In fact, there's really only one case that I found where a lawyer was disciplined and where the idea of unbundled legal services came up, and that's a case of People v. Stevens. It's a presiding disciplinary judge case, and it's available on that judge's website. But really, as Justice Hood pointed out, that case involved a lawyer who engaged in representation of a client in a criminal case and really didn't diligently and competently represent their client, and as a defense to the disciplinary complaint, he said that they were engaged in unbundled legal services. Of course, the presiding disciplinary judge and the hearing panel decided that that was not supported by the evidence, and ultimately that lawyer was disciplined, but it wasn't because he was engaging in unbundled legal services. It was because he was not complying with the other rules of professional conduct. We all owe certain duties to our clients, and among them are the duties to competently and diligently and honestly and without any kind of conflict represent them. And that lawyer didn't do that. In preparation for today's webinar, I've also called the National Organization of Bar Counsel. I emailed them, and these are my counterparts in all the other states throughout the United States. What I did is I sent an email and I said, hey, are there any public cases that you can refer me to where lawyers in your state have been disciplined for engaging in this kind of work? And so far I've not received a published opinion from those lawyers. And that was consistent with what I found last year when I engaged in the same kind of a question, whether or not lawyers had been disciplined for engaging in limited representation. Subsequently, we had a lot of concerns about whether or not you're more likely to get a malpractice claim if you engage in this kind of work. And what we found is the same thing, is that you're not more likely to get a malpractice claim if you're engaged in this kind of work. In fact, the Jefferson County Bar Association did a study, and they interviewed several malpractice insurance carriers and other persons and lawyers in private practice. And what they found was that lawyers engaging in limited representation were not being charged additional fees for their malpractice insurance, and they were not receiving malpractice claims at a higher rate. And many of the lawyers that reported back to that study indicated that they their malpractice insurance carrier didn't care whether or not they were engaged in limited scope or full scope, as long as it was within the parameters of their malpractice insurance carriers' field of practice. So, you know, if they engaged in family law, as long as it was in family law and they weren't trying to do a different area of law. So the concerns that many practitioners have really haven't panned out over the years. Again, I've been looking at this, I guess now this will be my 4th year that I've looked at this, and I've just not seen that kind of disciplinary case or malpractice issues that some people may have concerns. However, the court took this very seriously and modified the rules in 2012 to allow limited representation where you can represent a client in a case and then get out fairly quickly. And so that was in, I like to think, in response to some of these meetings we had with Bar Association members throughout the state, and in response to concerns they have, whether or not these concerns had been, whether or not the concerns, you know, were represented in the disciplinary cases or not. So if you're going to engage in unbundled legal services or limited scope representation, you need to look at these 4 rules that I have on the screen. I guess technically it's 5 rules. So that's Rule 1.2c of the Rules of Professional Conduct, Rule 11b and Rule 311b. That's the Rule of Civil Procedure and the corresponding County Court Rule of Civil Procedure dealing with limited representation. You also want to take a look at Rule 121, Section 1-1, Paragraph 5. This is the section Justice Hood mentioned to you that was modified recently, and in response to some of these Bar Association visits that Justice Hobbs and various other members of the Court and Bar Association had been on. And then C.R.C.P. This is the appellate rule that Justice Hood mentioned that was also modified in response to some of the concerns that appellate practitioners had in representing people on a limited scope basis. So every year you should take it, not every year, on a frequent basis you should take a look at the rules of professional conduct. Whether you do that every month, every week, however you choose to do it, it's important to take a look at them because they do change. And 1.2c is the rule that sets forth the ethical considerations you might have if you're going to engage in limited scope representation. What it says is that you have to, in order to limit, you may limit the scope or the objective of the representation as long as the client consents and as long as it's reasonable under the circumstances. Now, I've kind of paraphrased what it says because the real key word here is informed consent. And whether it's reasonable is something that you'll also have to consider. So those are 2 things we'll talk about. First, whether it's reasonable to engage in limited scope representation is something the lawyer is going to have to make the decision on. So the lawyer will need to take a look at the facts of the case, the type of case, and what's being asked and what kind of relief is being sought to determine whether or not it's reasonable. As I travel throughout the state talking about this, I've learned that some lawyers think that it's not reasonable in certain areas of law. I had a lawyer in Colorado Springs mention to me that patent law was not an area of law that would be right for this kind of representation. And I don't know much about patent law, so I didn't quarrel with him because I think that was his expertise. Now, there'll be other areas or other practitioners, maybe even in patent law, that might have a different opinion. But it's really something that you'll have to decide in your practice, whether it's good for you and your clients, and then whether it's reasonable in that specific legal matter that you're being asked to handle. Now, the case of a lawyer representing a client in a criminal case on one charge but not the other charge is certainly not reasonable, and there could be other examples we could talk about. However, there really isn't a rule that says what is reasonable and not reasonable, and there's not a specific list of what's reasonable and not reasonable. I'm sure Mr. Clay will have some good examples for you as a private practitioner in instances where he maybe thought that it wasn't reasonable, or maybe where he thought it was reasonable. Certainly, we see a lot of practitioners engaging in this kind of work in the family law arena. Informed consent is defined by the rules, and that's defined by Rule 1.0e. And informed consent essentially means you have to explain the risks and the alternatives to your client prior to engaging in this type of work. So you have to give them the appropriate information for them to make that decision. That really is a conversation you should have at the outset. If you're going to engage in this kind of work, this is best to have the discussion with your client right away, and so that you can each know what the expectation is, and each have a good understanding of what's going to happen during the course of the representation. So when you have a discussion about the risks and the alternatives, I think it could go something like this. You could explain that the alternative to full scope or full bundle representation is unbundled representation or limited scope representation. What that means is I could represent you on a particular part of the case, and you could continue to represent yourself on the remaining part of the case. So the alternative to full scope is limited scope, and the alternative to limited scope would be full scope. Now, if you're explaining the risks to your client, you want to make sure that you are careful. You have to explain that maybe I assist you in drafting a particular document or pleading that you file in court, and that's fine. But if the court then asks for an evidentiary hearing or asks for legal argument on the case, and you may not be prepared to do that, you could have, you may be at a disadvantage when the court either doesn't let you admit particular evidence, or when the court doesn't listen to your argument because you're not citing a specific standard or things that the court needs to hear. So those are things that you would talk with your client about. And clients understand that. I think if you put it in the context of, of the rules of evidence and rules of procedure and those types of things. For instance, you might file a motion to dismiss, and if the court decides there needs to be an evidentiary hearing, you may not be able to admit the smoking gun because you don't know the rules of evidence, and it could be difficult. I've seen cases where this kind of thing has happened, and the client asks for continuance and then asks the court for another hearing and then hires the lawyer. It actually brings the lawyer back on as a full scope representation, which is permissible by the rules of professional conduct. The agreement to engage in limited scope representation does not have to be in writing. However, it's best practice that it is in writing. So the rule of professional conduct that you want to look at here is Rule 1.5b. What it states is that if you've not previously represented a client, you have to do a written statement for the basis or rate of the fee. And it says that you need to include that so the client will be on notice as to what you're going to charge for the legal services. We suggest that a good opportunity is to put in your scope of representation in that particular written basis for your fee. It's not required by the rules that you put the scope in your written basis of the fee, and it's not required by the rules that you write that it is a limited scope. However, it's best practice and would be best to serve your client and to serve you in the event that there's some confusion down the road. And we all know that cases sometimes take upwards of 6 months or a year or 2 years, and oftentimes clients don't remember what the scope of the representation might be, or they may recall it differently than you. And so if you have that document and you've created a document or writing that has the scope and the limited nature of that scope, then you can show the client that, and then if there's a disagreement, it's easily resolved. An attorney may undertake limited representation in preparing and drafting pleadings or papers filed by a pro se party in the court. This is Rule 11b. Now, 1.2c is the ethical rule of professional conduct, and initially 11b was the corresponding rule of procedure that allowed lawyers to engage in this kind of limited representation. What the court has found, and ultimately resulted in some modification of other rules, is that Rule 11b really doesn't address how you engage in limited representation when you are before the court. So when you are maybe entering on a limited scope for a temporary orders hearing, and that's the only purpose. So later on we'll talk about Rule 121 and how that was modified to kind of connect these two rules so that you can engage in limited representation ethically under 1.2. And so you can draft pleadings and papers under 11B, but then you can also do this kind of in-court representation and withdraw when you're done. So they used to call this ghostwriting under Rule 11B, and Justice Hobbs, when we did this presentation, always made a joke that, he took the ghost out of ghostwriting, and it really is true, because if you're doing this correctly, you're identifying who you are, and your name and your phone number and your bar number on that particular document that your client's filing with the court. Now, it's incumbent upon the lawyer to tell the client that they must include this information on the pleading that they're assisting in the drafting of. Now, I would suggest that if you're preparing a document for a client and you're engaging in what we used to call as ghostwriting, that you put that information at the bottom of that document so that your client will have it there and it'll be there when you give it to your client. And I would also encourage you to keep a copy, because sometimes clients manipulate documents and you want to be sure that you have the document that you provided the client. Now, the information about your bar number, your name, your address, that does not constitute an entry of appearance if you're going to engage in this limited representation and drafting pleadings and documents on behalf of a client. It is essentially a notice to the court so that everyone's on notice that a lawyer participated in the drafting of those pleadings. Now, if you put your name and information in the caption of that pleading, it is very likely that the clerk of the court would consider that as some kind of an entry of appearance. So, be sure that you look at how you're including that information and that you include the appropriate information. If you include it in the caption, they may inadvertently think that you're representing the client on a full scope, or that you're representing the client. As you know, if you appear on behalf of a client in court, or if you file a pleading on behalf of a client in court, or if you file an entry of appearance in a case, those are all considered general appearances under Rule 121. So it's important that if you're going to engage in limited representation, we do it correctly. And one tip is just to not include the information in the caption, but to keep it as a footer or something along those lines. Now, ghostwriting is not permitted in the Federal District Court in Colorado. In the case that I have on the screen, this Johnson versus the Board of County Commissioners, is the case that essentially stands for that proposition. In that case, Senior Judge Kane made it very clear that lawyers who engage in ghostwriting in federal court expose themselves to contempt and also to ethical violations with their federal with the federal bench. That case came out in 1994, and I can tell you that the federal court has not changed their mind on that. And what I mean by that is that in a recent ABA article called "Ghostwriting and the Invisible Lawyer," Senior Judge John Kane indicated again that ghostwriting is not permissible in federal court, and went on to say that unbundled legal services is essentially the same thing, and it's also not permitted in the federal court. Now, I will say that in this particular paper and comments by Judge Kane from last year, Judge Kane's position hasn't changed at all. And in fact, he equated unbundled legal services as the moral equivalent of putting someone adrift in a stormy sea without oars, rudder, or compass, and referred to unbundled legal services as the stepsister of ghostwriting. And so if you're going to practice in federal court, you want to be sure to be in compliance with this case, with the rules of procedure there in federal court, which do not permit this kind of work. Now, I think there are some caveats there in the bankruptcy court and the immigration court. And those specialty courts, I would encourage you to look very carefully at their rules and follow their procedures, because they tend to change quite a bit. But for now, I would not engage in this kind of work in federal court. I do think that there's a chance down the road that this is gonna that this will change. It hasn't now, but I feel that there's going to be more of a focus on this maybe as the years go on, and maybe a change in federal court in the next 10 years or something. But for now, we all want to follow their rules. So make sure to include that your information on the pleading. It does not constitute an entry of appearance. Now, Rule 121, 1-15, this is the rule that we mentioned earlier and that Justice Hood mentioned earlier also. This rule was modified by the courts in 2012. I believe it was October of 2012, and it really was as as part of a larger discussion as to how to get people to engage in more limited representation, how to address the concerns that practitioners had when they engaged in limited representation. A lot of the feedback we had was that if I helped somebody on a pro bono basis in a family law case, maybe a child custody case, that I would somehow be on the hook for 5 years and the court would never let me out. Under these new rules, that's just not the case. Lawyers can enter their appearance and can withdraw without a court order as long as they follow the rules under Rule 121, 1-1, paragraph 5. Okay, and it looks like that rule was adopted in 2012. I think it's January 2012 is when it was effective. But essentially, Rule 121 allows the lawyer to undertake limited representation of a pro se party in a court proceeding. So this is the rule that really links the 1.2c, which is the rule of professional conduct that says you can do it, it's ethical, and 11b, which says you can write documents. This is the one that allows you to now appear in court and to engage in this limited representation. More than likely, this has been going on in your district for a while. It had been going on in Denver with the Metro Volunteer Lawyers and with various other legal service agencies where they were doing limited representation in the courts, either through the family court or other programs was allowing this kind of representation. But now really what we do is we have this rule that where it codifies it and specifically permits this kind of work. It says that you can engage in limited representation at the request of the client and with the consent of the client. But you have to follow the procedures and file the documents that we're going to talk about in a minute prior to the proceeding or simultaneously with the proceeding. If you do that, once you're done with that particular proceeding where you're entered in on a limited representation basis, you are granted withdrawal from the case without any order of the court. This is important because, as you know, under our normal rules, when you enter your appearance, you must then file a motion to withdraw, and the opposing side has a particular amount of time to respond, to object. I think it's 14 days, and then the client has an objection period also, and then the court rules on that motion to withdraw. Under this new Rule 121, that's not how it works. If you file the appropriate documentation simultaneously with the hearing or prior to the hearing, you essentially file a notice of completion and then you're out of the case. I'm going to get this document and show you what the document looks like. So let me find it here. So I don't know if you can see this document. This is a notice of completion of limited appearance by an attorney. I'm presuming that you can see it, but at the very bottom, and I'll highlight it here, this is JDF Form 1336. This is the notice of completion of a limited representation in a family law case. So if you go into the court's website, you'll find all the pre-printed judicial forms. There are forms for domestic and for civil, and they track the same information. Essentially what they do is they say that I am going to engage in this limited appearance with the consent of my client, and the form numbers at the bottom of the page, and you provide a copy to the court and counsel on the other side. If you do this properly, you've effectively entered your appearance on a limited scope basis. I do want to show you one other one here. Let's see if I can find it. I'm not finding it right in front of me at this point. So if you look at these documents, JDF 1334 to 1336, those are the forms in the domestic proceedings that you would use that allow this type of entry of appearance. Now, if you want to do this kind of work in a civil case, you are permitted to do that as well, and there are forms that have been created by the court and that are approved by the court. Those forms are JDF 632, 631, and 630. These are the forms that allow you to engage in limited scope representation before the court. And again, this is at the consent of the client and at the request of the client. And upon completion of this with the client, you're permitted to withdraw from the case without any further action by the court. Okay. It looks like I had my date wrong. The amended rule was amended October 20th, 2011, and I believe it went into effect January 1st, 2012. So it's been around for a few years now, and I know that in many jurisdictions, lawyers are taking advantage of this rule and now feeling more comfortable that they can engage in limited scope representation without being on the hook for 18 years, as they described before. In response to the changes in Rule 121, the Colorado Court of Appeals and lawyers and members of the Bar Association recommended the Appellate Rule 5 be modified to engage in limited representation. And a year after Rule 121 was amended, the court amended Rule 5E. This also allows for limited representation of a pro se party in a civil appellate proceeding. Now, this is an interesting rule because it tracks a lot of the same information as Rule 121, but it has more limitations on it. So if you're going to engage in limited scope representation in your appellate practice, I would take a close look at this rule because there are certain things you're allowed to do under 5E in a limited representation capacity in an appellate matter that really are different than what you can do in a general family law or civil case. So it's important to note here, though, that since 1996, when Chief Judge Connie Peterson wrote that article, until now, there really has been a shift by the court to encourage this kind of representation and to make the rules and to make it permissible to engage in this kind of representation. And I think that's an important thing to note when you decide whether or not this is something you want to do in your practice or something that you want to discuss with your clients as to whether or not it's a benefit for them. I agree with Justice Hood that the law is changing and the practice of law is changing. And the future of law practice is going to involve a substantial portion of this limited representation, and it's going to involve this modest means representation. And I know Mr. Clay worked very hard on the committee with the Modest Means Task Force, and he'll discuss a little bit about it with you, but what that task force is trying to do is bridge the gap between the persons who cannot afford an attorney but make too much money to receive legal services or some kind of public assistance lawyer. So the Modest Means Task Force has engaged in this toolkit that was mentioned by Justice Hood, and I would, and also by Mr. Clay, and is available for bar members and non-bar members on the Bar Association website. It's a really good tool. In fact, all of the forms and all of the rules we're talking about are in this book. And there's flowcharts that discuss how to engage in this limited representation in this book, along with links to articles in the Colorado Lawyer, and along with links to the ethics opinions that are relevant to this particular practice area. I do want to note that if you have an interest in reviewing some materials, I did write an article in September 2011 in the Colorado Lawyer called The Ethical Considerations of Providing Unbundled Legal Services. That could be a good starting point for you if you have an interest in working in this type of practice area. And then Judge Taubman with the Court of Appeals and I wrote an article about the limited scope representation under this new Rule 121. And we addressed some of the concerns that practitioners have, and it's also, again, a good starting point for you if you engage in this kind of work. That was published by the Colorado Lawyer in November 2011, and I believe those articles are available on the Internet or on the Bar Association website. So those are two places to look if you have an interest in kind of getting started here in Colorado in this practice area. I would encourage you to also take a look at this successful business planning representing the modest income client. And I'm not saying that because I'm trying to pitch a book for the Bar Association or because I had actually participated in the drafting of this document or this book. I say it because I think it's very helpful. It's helpful in the sense that it has tips and tricks that you can look at and pitfalls in almost every area of modest means representation, whether it be ethics, whether it be marketing, whether it be office sharing, or whether it be limited representation. And also a cool thing that you can get if you purchase this book is some software. And I don't know if it comes with it online when you buy it, but the software allows you to kind of develop a business plan where you're able to then manage how much, how many clients you might need at a particular rate to make an income that you think is viable for you and your family. So that's a really attractive piece of software that comes with the book and makes it a valuable resource for you. Why do you want to do this kind of stuff? I'm a very big access to justice kind of person. I think our courts are for our people, and people should have access and be able to get the relief they're seeking. So if you're going to engage in unbundled legal services, you could be doing it for that reason. Maybe you want to help pro se parties or pro bono people. And maybe you want to do it because you want to try a new practice area. Maybe that's the reason why you want to engage in limited scope representation. I can tell you there's a large law firm here in Denver that does corporate law, where they also do family law clinics when they teach the lawyers how to do family law so they can do this limited scope representation in the Denver Family Court. So they do that as a pro bono part of their law firm's larger capacity in representing clients here in Denver. So this is an opportunity for you to maybe expand your practice area, or for some people, maybe to expand their practice. Not all of these limited scope clients are going to be limited forever. At some point, the economy might be in a position where everyone can afford to pay a full fee. That's just not what we're seeing now. And so it's something you want to consider as to how you want to develop your practice, how you want to help your legal community and your community as a lawyer. Now, I have about 3 more minutes, so we'll go through a few rules of professional conduct. I say this all the time, and I jokingly say it, but it's true. If you engage in limited representation, it doesn't mean that you can limit your competence. You can't limit your diligence or limit, your research. You have to work hard for your client. You're still obligated to follow all the rules of professional conduct, including the rule on being competent, being diligent, on communication with your client, and on honesty with your client. You can't limit those things if you're engaging in a limited scope representation. You need to make sure that the matter that you're handling, that you're working diligently and on it as best you can. Now, if you're going to engage in limited scope representation, you have to be sure that you're charging a reasonable fee. So I say this because some lawyers might think that if they engage in limited representation, then maybe it's okay to charge the same fee that they're charging for a full scope representation. Well, that could be an issue if there's not some other factors set forth as to why that fee should be the same. If you're going to limit the scope and only do one, maybe a temporary orders hearing in a family law case as opposed to the whole case, there's probably not a justifiable reason why you would charge your whole fee. That just doesn't seem reasonable. Certainly there might be emergency hearings or circumstances that could make it reasonable, but be sure that you include the basis and rate of your fee in writing, and that you include the scope, and that your fee is reasonable. For a list of factors on how and what is a reasonable fee, I would refer you to Rule 1.5a. It has various factors, including your experience, the difficulty of the case, the nature of the case, how long the matter would take, and the going rate in the community. Those are all generally ideas on what comes into play on a reasonable fee. Now, if you engage in limited representation, there are some concerns that you might have in terms of who do you serve process, who do you communicate with, and those kinds of things. And that's pretty easy. It can seem difficult from a practitioner standpoint, but really, if you don't know, you simply ask the opposing counsel. So in an instance where a pro se party is represented on a limited basis for a particular part of a family law case, but not the other part, if there's any uncertainty that you have, you don't want to violate Rule 4.2, which prohibits contact with represented parties. And so you just ask the opposing party, are you representing them on this particular matter? And when they say no, then you're permitted to speak to that unrepresented pro se party. If the lawyer is engaging in limited representation correctly, the notice of limited representation will include the scope of the representation, and then you'll know, and you'll have a good basis as to what they are or not helping the client on. With that, that's about 40 minutes for me. I will tell you that I have some sources of information here. I can tell you that my phone number is on this slideshow. You're welcome to call me with questions. I can't give legal advice, but our office is always happy to point you in the right direction. We'd rather lawyers get information up front so they can make good decisions so that they can better help their clients and have more efficient, effective law practice. Thank you very much, and I'll be on the phone if anyone has questions.
And Robin, this is Robin?
Yes.
Hi, this is Justice Hood. As I told you, I need to leave now, so thank you for the opportunity to participate in this, and I appreciate hearing from Mr. Espinoza, and I'm sorry that I won't be able to hear Mr. Clay, but good luck to everyone.
Well, thank you, Justice Hood, for joining us.
Thank you.
And thank you, Adam, for a great presentation. I'm going to turn it over to Aaron Clay at this point. He's a private practice attorney over on the Western Slope in Delta. There is no PowerPoint for this portion of the webinar, so it will be audio. So Aaron, when you're ready, go ahead and start your portion.
Okay, thanks, Robin.
You're welcome.
My role here is to talk about where the rubber meets the road. We have great comments from a Supreme Court justice and great comments from a attorney's counsel attorney, but maybe none of them has ever done a limited scope representation. And so they've asked me as a small town practitioner to talk about that. So that's what I'm going to do. I've practiced law in Delta County since 1979, about 34 years. Small county, small rural area. By some standards, we are the 7th most poor county in Colorado. Depends on which standard you look at. But not a lot of rich folk here that I could make a living off of. And in a small town practice, you end up doing just a little bit of everything. A little bit of divorce, a little bit of contracts, a little bit of wills and estates, just a mishmash of various things. And sort of by default, I've been doing unbundled legal services for most of the last 34 years. Didn't know that's what we called it until about 15 years ago, but been doing it for a long time. And so I've been asked to talk about what kinds of cases are appropriate for unbundled services, how you get into them, how you get out of them, how you avoid some ethical traps. And so that's what I will plan to do here. My interest in this comes from I was on the Access to Justice Committee when it was first formed, gosh, about 15 years ago, maybe 10 or 12 years ago. That's been off into some local Access to Justice committees, and I'm on our local committee over here. And then a couple years ago, they formed the Moderate Income Task Force because they saw that there was a growing segment of our communities that could not afford full-service attorneys, but made too much money to qualify for any sort of pro bono services, and those are the folks that keep ending up in the courthouse on their own, pro se. The Judicial Department has reacted to that in some really good ways. They've sent pro se litigant assistants around the state to help people fill out the forms. The Judicial Department forms are wonderful. If you don't use them, you're missing an opportunity to use what the best brains in Colorado have put together for forms. And they've really stepped up in putting out things that try to make it easier for people to represent themselves. But there are those occasions where it just doesn't work. People don't understand the law, they don't understand the process, they don't understand the system, and so there are times when they just need some assistance or a nudge or something to go through the whole process. And so that's where limited scope services have come to be. Another name for unbundling is limited scope services, a la carte legal services, discrete task representation. Those are all the names for the same thing that we do. The first thing I want to caution you is that this is, in taking on limited scope representation, it is not an opportunity to dodge your other ethical requirements, and that was sort of the last thing that Adam said, and I'm going to make it the first thing I say, is that everything else that we're required to do as attorneys ethically still applies. When you're doing a small job for someone or a limited scope job, you still have all the other obligations that you have to treat everyone fairly, to not mislead anyone, to tell the truth, to represent them competently, all those things. And so it's not a way to evade some ethical obligation. It's a way to serve people who need just some services but don't need the full scope of everything that you might be able to do. So in what kind of cases do I do that are limited scope? Well, several come to mind. Evictions are a really good example. I represent a lot of clients who don't hire companies to manage their properties. They have a couple of houses or an apartment building or something that they are managing themselves, and from time to time they have to evict someone. The forms to do an eviction are pretty straightforward, and they are available online. But getting to the court sometimes is pretty technical. You have to very strict rules about how you file and serve a 3-day notice to quit or a notice of termination. And so one piece of unbundling would be, I will do a contract with someone that says you need to evict this person. I'll help you up to the point of where you're going to file the court case. So I'll help you prepare the appropriate notices. I'll help them get served properly. And then once that's packaged and ready to go, I might even help you fill out the JDF forms for an FED, but you don't need to pay me to go sit outside of the courtroom for 2 hours while the court wades through a whole bunch of eviction cases. That's a waste of my time and your money. So let's prepare them. If I'm ghostwriting, I'll put my name and address on there, but I'm not going to show up in court with you. Eviction cases are really straightforward. Most people don't need an attorney to speak for them. It's pretty clear. If they've done the paperwork properly up front, they're pretty well slam dunk. And so that's a really good time that you can unbundle and say, I'll charge you so much for getting us to that point. We have a set fee for that. We've done enough of them that we know pretty much exactly what it's going to take to get them to the courthouse. And so we say, okay, for X number of dollars, we'll do everything that's necessary to get you to the courthouse, and then you go in and talk to the judge yourself. You don't need us to go with you. And I should stop there and say that clients really appreciate when you give them a set fee or flat fee instead of saying, well, we charge so much an hour, because they feel that that's a blank check. If I say it's so many hours, well, how many hours? Well, I don't know. Could be 2, could be 4. That's a big difference to them. If I say for this service it's going to be blank dollars, they can calculate. That's just a business decision, and they say, yes, it's worth that to me to get to the door of the courthouse. And so that's a really good example of unbundling. And then typically I don't even have to see them after they go to the court. The court goes through the process. The court issues the writ of restitution. I don't have to prepare that. Nobody has to prepare that. The court just issues it, and then they go to the sheriff if they need to finish up. And once in a while they come back, but typically we just get them to the courthouse, and they go the rest of the way on their own. Another example is small claims. A lot of times we have people with a $1,500 dispute over a car repair, or a rental dispute that's a few $1,000s. Doesn't make sense for them from a business perspective to hire a full-blown attorney to take on something like that and spend $800 to get $1,600. That just doesn't make sense. And so I will unbundle and say, okay, I will help you fill out the small claims application, because there are some technical things that you need to do here, and I will explain the process to you. It's a fairly straightforward process, but it's a little intimidating to people if the first time at least that they go through the process. And then I'm going to send you to the courthouse, and you'll have a package of papers that all you have to do is walk over there and hand it to the clerk with your check, and then they will tell you when to come back and tell your story to the judge. And then I will say, and what you're going to find out is you're probably going to get your judgment, if what you tell me is true and the judge believes it, you're going to get a judgment. You may have trouble collecting that judgment. And so if you try and fail, come back, and then I will help you get a garnishment or whatever process we might do to execute on that. So the front end and the back end of a small claims case can be very helpful to people. Once again, I say, okay, to get you the appropriate forms for your small claims case filled out properly with the right words, it costs you X dollars. When you come back at the end, if it's a standard garnishment, I'll fill out the garnishment forms for you, and you can then take them back and file them, and that'll cost you X dollars. And they really appreciate the fact that they know exactly what it's going to cost them going in and out. Another area that we do unbundling frequently is people who are in the middle of a pro se divorce. And usually they come to us in the middle. They're able to fill out the papers themselves and get it filed, and the court clerks are really good about that. They hand them the, over here I think for 20 bucks they can get the do-it-yourself divorce kit from the court that has all the JDF forms and the financial affidavits and everything. And most people are pretty competent to fill those out. And then they go through the initial case management conference, and they get a little intimidated because the case management person is giving them words that they don't understand, and all of a sudden they're now feel like they're in over their head. Frequently, we'll at that point they come in and say, "Do you want to take over my case?" Well, there's a couple of issues there. We really don't like stepping into a case in the middle of it because we didn't control how it got started, and we don't know, all the background. But sometimes it's just better to sit down with them for an hour and say, let me give you a roadmap about how you might get through this whole thing. And sort of a written, here's the next step, and here's what you can anticipate, and here's what you need to do. And at some point, you're going to, if you don't get it settled and a stipulation filed, you're going to be back, and the court's going to have told you that you have to file a witness and exhibits list by a certain time prior to your final orders hearing. That's pretty intimidating, because if you don't file the right witnesses and the right exhibits, you could really mess your case up. So we say, when you get to that point, if you don't have it resolved by then, come back, and for blank dollars, we will help you fill out your witness and exhibits list and give you some counsel and advice about what witnesses you need. You don't need to call 47 witnesses, but let's figure out the 4 or 5 best witnesses for your case. You don't need 4,000 exhibits. You don't need every check that you wrote in the last 5 years. Let's sit down and figure out which exhibits make sense, and the judges are going to really appreciate that, because they don't want to listen to 47 witnesses say the same thing. They don't want to have to wade through 4,000 exhibits if 20 exhibits will accomplish the same thing. So that's helping the judges get through this whole process too. But it helps the client, helps them focus on their particular case and their particular need and how to get ready for their final orders hearing. So frequently we do that, and then we may never see them again. Another way that we help is sometimes they're in a pro se case and they've kind of muddled along and they get to a certain point, and then they get an order from the judge that says, I need a brief on this legal issue. And that's typically when there's one side is pro se and the other is represented by counsel, because the other counsel has raised some legal issue that may or may not be unique or whatever, and the judge just needs some guidance. Well, if only one side has a lawyer, then the guidance the judge is going to give is going to be a little biased, even though as officers of the court we're supposed to disclose all the cases for and again our position, but you're also going to highlight the fors and lowlight the agains. So in our adversary system, to make that balance, they may need a brief. The pro se person may need a brief that could be filed. And this is where the ghostwriting comes in. Briefs are a great opportunity to ghostwrite. It's something that someone who's not trained in the law has a really tough time doing the research and figuring out how to distinguish this case from that case and what makes this ruling, which looks completely different, the same as that ruling, and all those things that we tried to learn in law school. So briefs are a wonderful opportunity to say to someone, the judge has given you this order and you have to have this brief in by a certain date, and I'm willing to do that for whatever. And that may be a time where you'd want to do it on an hourly basis with an estimate of time, because as we all know, when you start doing research, there may be 14 rabbit trails before you find the right rabbit hole, and you have to think about all that time that you've invested going down the wrong trails. But Doing a brief is a really good opportunity. Give you an example. I had a case where a guy filed a quiet title suit pro se over a road dispute between him and his neighbor, and he filed a pro se quiet title suit. Neighbor hired a lawyer, and the first thing they filed was a motion to dismiss, saying, well, you don't have standing to file a quiet title suit over a public road. The issue was whether it was a public road or not. The court issued an order to show cause as a result of a Rule 12 motion. They brought it to us, and we said, well, because you don't know the difference between a quiet title suit and a declaratory judgment, that's why you're in this pickle. And so in short order, we were able to help them write a brief and actually help them amend their complaint to say what they really wanted to say was, I need a declaratory judgment. I don't need a quiet title. And so that was an example of a one-time thing. Cost them maybe $1,000, but it saved the entire case for them. And then we didn't have to go any farther in the case. We helped them get their complaint drafted properly and on down the road. Complaints and answers are actually the primary things that I think we do as ghostwriters or as assisting people to get into the case. Complaints are pretty technical a lot of times, and answers are really technical a lot of times. And people, if they don't file the appropriate answer, can lose good defenses that they have, statute of limitations or other things. And so I think it's a great opportunity to say, I don't want to be in your case. I'm not going to commit the next 2 years to litigating this with you. I'm not interested in doing the discovery, but I'll get you set up properly. I'll help you do a little research, and I'll prepare an answer and get you at least down the road so that you don't lose any of your rights because you just didn't know that you had them to file in the first place. When you're doing that, you need to remember that you're still under Rule 11. Even though you're not putting your name in the caption, and I'm with Adam, you don't want to ever put your name in the caption, or you get stuck in as a party, and you don't want that. But even though you're not putting your name in the caption, you're just putting it at the bottom of the paper saying, I helped draft this document. Anytime you do that, you have to comply with Rule 11, and that means that whatever you put in that complaint or that answer, based on the information that you have from your client, it's well grounded in fact. It's warranted by existing law. In other words, you're not just being frivolous about something. It's not interposed for any improper purpose. And that one is tough sometimes because a lot of times you have someone who comes in and says, I want to sue my neighbor. I don't like them. So what can I sue them for? Well, that person ought to probably be sent out the door pretty quickly because you're going to get into an ethical trap in a real hurry there. It needs to be a proper purpose for whatever you're doing. And read Rule 11 and see what else is in there that you're verifying that you, as an attorney, believe that you were complying with all those things. Ghostwriting is not an opportunity to avoid Rule 11. It's not an opportunity to say, well, I won't put my name on this, but if you want to try it, you go ahead. That's not ethical. If you put your name on it, if you help, then you are subject to Rule 11. And if you get to a point in this process where you feel like your client, even in this limited representation, your client is not complying, I think you have an obligation to stop and say, sorry, I'm not going to help you any farther. I don't know if you have an obligation to go to the court at that point. I don't think so, but I think you have an obligation to say, I'm not going to take this any farther with you. So complaints and answers, and that's also very helpful to the court, because what happens with pro se people many times is they don't know the right words, they don't know how to get it into the court, and so they end up fumbling along, and the court says, well, maybe you ought to amend this complaint. So you end up with a second amended complaint and a fourth amended complaint, and before the case is really at issue, there's been a whole lot of wasted time and energy on everybody's part, and the court gets very frustrated with that. So getting the case framed properly is really helpful to the judge in deciding the case down the road. We don't do a lot of limited appearances. In fact, I'm not sure I've ever done a limited appearance because they kind of scare me. I'm with the school that says that once you get into case, it's very difficult to get out of the case. Even though I know we have these new limited appearance rules, judges are a little reluctant to live with that, and so I'm a little reluctant to do a limited appearance. I also think that it's, unless it's a very specific limited appearance that says I'm only going to here to help with the, I don't know, whatever it is, the preliminary hearing or the preliminary restraining order hearing, and I'm not going to do the final restraining order hearing. I don't know, sometimes it's very hard to draw that line. So I have to be very, very careful about getting into limited appearances. When you begin to do a limited scope representation, it's really important that you decide early whether you're going to do that or not. And that takes, basically the interview process is going to be the same whether you're doing a limited scope or decide to do a full service representation, because you can't really tell whether it's an appropriate case for a limited scope until you know what all the issues are and what all the facts are. So you need to have that full hour-long maybe interview with the client saying what's this about and what's that about and who are the parties and how they are related and all those things that you have to do to get all the issues out on the table. And many times it's just not appropriate. If you in that interview process feel that the client is simply not capable of doing it themselves, you have an obligation to tell them that. You have to say, you know, I'd like to do this only a part way, but I think that's not in your best interest, and always the client's best interest is this touchstone there. So you need a really good diagnostic interview to figure out what the issues are and how is this case likely to go. After you do enough, you know, divorce cases or enough small claims or whatever, you kind of get a feel for that. Yeah, well, this, and of course, we all have said this is an easy divorce, and there are no easy divorces, but you can get a feel for whether or not the client is going to be able to muddle through the typical divorce and get to the end in some kind of fashion. You have to know what the relevant legal issues are, and you can't do that unless you do a pretty good interview. Are there potential counterclaims? If you're the claimant filing a complaint, are we going to draw a counterclaim that you don't want to deal with, and so on. You have to do that much of an interview. If, in fact, after all that, you and the client both feel that it is appropriate for a limited scope, that's the point where you need to really stop and take some time to draft a really, really good unbundled service agreement, that just limited scope agreement that just says, look, this litigation could take 2 years. I'm not in it for the 2 years. I'm in it for this piece. I'm going to help you draft your complaint. I'm going to help you get the defendant served. And by the way, that is a pretty good service for a lot of people. If they're trying to serve someone out of state, that may be a daunting task for a pro se litigant, and we can have resources that they may not be able to tap to get service on someone. But I'll help them get them served. Then once we file the complaint, you understand that you're on your own after that. I'm helping you get to the courthouse, but then you're on your own. Or I'm helping you get to the courthouse, and I'll take you through the first mediation. In our judicial district over here, after the case is at issue, we get a mediation order immediately, and we're set for mediation. We explain that to clients and say, I'm willing to participate up through the first mediation, and that probably will cost you about blank dollars. If it's settled at that point, then we're all happy and the case is done, and we file mediation. If it's not, then we have to begin discovery, and discovery can be very, very costly. You have to decide at that point whether you think the client is capable of doing the discovery. If not, then I think you have to say, I don't think you can do this discovery. It's going to be too technical. I don't think you want to fly to San Francisco and depose this expert. So you have to kind of make that judgment call. But whatever it is that you feel is appropriate for that particular client, that particular matter, needs to be put in writing. And that's on multiple levels. That's so that you and the client both have a clear expectation. As we all know, clients hear what they want to hear, and so in that initial interview, that over that hour, A lot of things are discussed and cussed and talked back and forth, and at the end of the day, the client may have heard something that you said way at the beginning that you had changed your mind by the end. The only way to make sure that that misunderstanding doesn't come back to haunt everybody is to have something in writing, a letter agreement or a formal fee agreement, something in writing that says, here's what I'm going to do, and here's how I'm going to charge you for what I'm going to do. Again, flat fees are a wonderful thing. If you have enough experience in something that you know you can do flat fees, do them. An example of that is I do a lot of limited scope representation in real estate matters. I've done lots of real estate work, and some clients need to have their hand held from beginning to end. But a lot of clients, especially if it's a for sale by owner on a residential property, there's a house in town, and you know, they put up a for sale by owner sign in the front door, and somebody drove by and liked their house. They come to me and say, gosh, I got a buyer. Now what do I do? Well, if they're sophisticated enough to take it that far, they may be sophisticated enough to complete the process themselves. So what we will do is we'll say, okay, what I'll do for you is I'll draft the contract, and then I'm going to send you to the title company, and you and the buyer go to the title company, and they'll do the closing for you. You don't need me to be there to assist with the title work, to review everything, to sit at the closing table with a closing agent that's done 1,000 of these just like this and probably knows better than I do how to do a closing. Let me draft the contract. Here's the price. Fixed fee again. Here's the price. I will answer any questions you have about the contract, and it's a fixed fee, so we'll keep massaging that contract until it is the way you want it. And that's important to them too, because it may not be the first draft that I draft. I don't understand something. They didn't tell me everything, whatever. And it might take 2 or 3 drafts to come up with the contract, but the fee is the fee. And that's not a business loser for me, because once it's on the computer, making changes is pretty easy. You know, a few little tweaks here and there to make it what they need to have. Doesn't cost me very much, but it impresses them that I said my word. I told them it was going to be X dollars for the contract, and that's what it costs. That is a really unbundled legal service, because then they can take the contract to the title company. I tell them how to do that, and then the title company takes it from there. If they run into a snag, they can always come back, and we'll figure it out from there. But I think that's a really good example of unbundling instead of making yourself available at the closing. Most of the time, they don't need an attorney at the closing. The title companies do that all the time. Similar, I do a lot of unbundled contracts and leases and title commitment work, those kinds of things. And those are usually one-shot things. Somebody will have a contract that the opposing, these are not litigants typically, the opposing negotiator has proposed. Here's a contract I'd like to use for this transaction. Bring it to me, I look it over, ask them whatever questions we need to have, and that's an unbundled legal service. Once I've reviewed it and they've sort of got my blessing on it, then it's theirs to go and perform. I'm not going to be involved in the actual transaction. I might, but typically if they're, and these are usually business folk, they're competent enough to take care of their own affairs. They don't need me to hold their hand to go through that process. The other thing that you have to be aware of is whether or not your clients, and I'm kind of switching back to on a litigation track, if you're trying to decide whether you're going to unbundle some litigation that's going on, you have to make sure that the client has the ability and the resources to do this themselves. That used to be an issue when, and I'm old enough now to remember before we had LexisNexis and Westlaw, when only we could get into the law library over at the courthouse. It seemed like we and the prisoners had law books, but nobody else had law books. Well, that was really a handicap to people. That handicap has gone away a lot with the advent of all the resources that are available on the internet, all the statutes and all the cases that are available to the general public. And I think that's a wonderful development for our society. I think that not just lawyers can read all those cases now. Although now we get lots of people saying, well, I read this case and it says thus and so, and then when you read it, it doesn't say thus and so particularly. But I think that's a wonderful development, and so people are much more able to be pro se litigants because they have access to those things. The other thing is that they do have access to the judicial forms, and the JDFs are wonderful. They cover so many things, and Attorneys should use them more. I probably should use them more than I do also, but they just cover so many things. And judges like them because they get used to them. They see the same form coming in. They know where to look for the things that they need to find. If it's a custom drafted 12-page letter from a pro se client, they have to wade through that and highlight and try to figure out what they need to know. If it's the JDF financial affidavit, they know which lines they need to look at to figure out what's going on. So with those forms available, it's much easier for people to be pro se. And by the way, if you're just helping a pro se litigant fill out a form, you don't have to put your name on there as having ghostwritten that. That filling out a form is, I guess, not considered legal practice. It's just helping someone. But still, in those forms, there's a lot of areas where there are gray areas, and there are things that need to be said that don't readily appear in the form. So you can really provide a service to people by simply saying, let's put these forms out here. I'll help you pencil in what needs to go, and then you go back to your computer and you fill it out and get it filed with the court. Really good assistance to people. Those forms are intimidating to a lot of people, depending on what it is, but a lot of times they are intimidating, and you can help them get over that intimidation factor, sometimes very quickly and easily. And then as part of the fee agreement or the letter agreement that you're going to write that says, here's what I'm going to do, and here's what I'm going to charge you, it's always a good idea to say, and here's what I'm not going to do. In a divorce case, I am not going to attend any of your hearings. So don't call me the day before your hearing and say, I've got a preliminary custody hearing tomorrow, can you be there? I'm not doing that for you. I'm going to help you get your paperwork filed, but you got to do your own hearings. And so don't call me the night before, and they still will call you. It'll happen every time. But then you can say, remember, I wrote to you and said I'm not doing that, and I'm not going to be there tomorrow, and I'm sorry, you have to take care of that. If you are willing to prepare them for the hearing, that needs to go into the fee agreement or the letter agreement that says, I'll spend 2 hours with you a week before your hearing to get your witness list and your documents list together, your exhibits list, and I'll prepare you to go to the hearing, but you don't want to pay me to sit through a 2-day custody hearing. So I'm stopping at that point. It's important for them to understand what you're not going to do to them. And that's a really nice time to sort of lay out a roadmap. Most cases are pretty similar. Divorce case, you're going to have the initial case management conference, and then you may have some temporary orders hearings, and then you're going to have some settlement negotiations, and all that stuff that is pretty much similar in every case. You could lay out that roadmap and say, here's where I stop on this road, and then here's what you're going to need to continue to do. That's really a good idea, because then they know what they're going to be expected to do up front, and it doesn't come as a surprise to them when down the road you're done and they still have 1.5 miles to go to get to the finish line, and they say, wait a minute, I didn't understand that we were going to be this far. If you've laid that out in advance, then they have a much better chance of continuing on. And then finally, and this is another reason that you need to have a really good initial interview, and that is that there may be other problems that you see in that initial interview that don't relate to the problem that the client brings to you. It happens frequently in probate cases and those kinds of things where they may come to me and there's some issue, and then in the course of the conversation I discovered that maybe mom or dad needs to have a guardianship or conservatorship, and the issue is not just getting a power of attorney done or getting some deed work done. At that point, I think you have an ethical obligation to explore a little farther and say, what is the relationship here? What's going on? And if I unbundle from this, have I done a disservice to my client because I'm not giving them the opportunity to solve this other problem? I think you at least have the obligation to raise that problem, and if they decline, then I think you ought to put as part of your fee agreement, and we did talk about guardianships and conservatorships, and you've chosen not to hire us to go down that road, and so we are just doing this service, and if you need that guardianship or conservatorship, that's going to be a different conversation at a different time. And then what always happens, not always, what happens frequently is you've done and unbundled, you've got them in the courthouse, and then they run into a roadblock somewhere down the road that nobody anticipated. And they're going to come back and they're going to say, I need you to do this. I think you have to be very careful when you get into that because there may be some reason that they're in the roadblock. It may be that they didn't quite tell you everything in the initial conversation, the initial interview. Believe it or not, that happens a lot of times with clients that they either want to disclose everything to you or just forgot some of the information that might have been important, and it came up a year later or 3 months later, and now they're in a pickle because this information now has come out. You got to be very careful that that may change how you would have approached the case had you known about it initially. And we do limited scope representation for a reason, and that is because we're limiting our scope, we can charge less. The minute that you go beyond that, now you've changed that expectation. So you be very, very careful when you do that, that you have a different fee agreement that says this is no longer limited, or it's going to be, I'm going to take you through that next step, but then we're going to stop and we have to talk about this. And that's where that roadmap or the checklist or whatever you want to say, the bullet list, can be very helpful to say, wait, I stopped here and you're 3 bullets down the road. What happened in the meantime? What do I need to know about that happened in here before I can decide whether I want to take you to that next bullet or that next place on the roadmap? There are some cases that simply should not be unbundled, in my opinion. And I don't think criminal matters can be really well unbundled unless it's a very petty crime or something, and they're just going to appear in municipal court, and they just need to know how to get to municipal court and what the process is. But I think that the outcome of criminal matters can be so drastic, and they can turn so quickly, and they always have an attorney on the other side because the DA is always there. I don't think that most criminal matters are appropriate for unbundled services. I just think that there's too many potential pitfalls there. Also, I think that complex litigation, most attorneys don't do a good job with complex litigation, let alone pro se clients. So I think unbundling works really well with the sort of plain vanilla things that we see, like evictions and divorce and neighbor problems and neighbor disputes. But if it's a antitrust case or anything like that, I think you just need to stay away from it. We do as lawyers anyway. And this is also not an opportunity for you to say, well, I don't know how to do this, and so I'm going to unbundle from it. If you realize that somewhere in this case there's going to need expertise that you don't have, you cannot say, I'll take you to this point and then I'm stopping because I don't know how to do that next step. That's not in your client's best interest. At that point, what you have to do is say, I'll take you to this point, but since this is beyond my capability, I have to then get other counsel in. And we have to have that conversation up front about, we're going to have to get other counsel. We may need to get them now. Who's going to pay for that? How's that's going to happen? But I'm not going to unbundle just because I can't. I don't know how to do this next step. An example of that is I do a lot of water work. I have a water case pending now where one of the issues involves whether or not a public utility has to provide water to my client. That's going to take a Public Utilities Commission hearing in Denver probably. I have no idea about how to do a PUC hearing and don't really care to know how to do a PUC hearing. And so early on when we got into that, I said to my client, we're going to get to this point. I'm predicting that the opposers are going to say, here's the issue, and that's an issue that I don't have any competence to deal with. And they had already thought of that, actually, and had another attorney engaged, and we got to that point. Sure enough, we had to get the other attorney engaged to go through the PUC matter. That's not a point where you can say, I'll take you this far, and then when we get to the PUC matter, I'm out of here, and you take it from there. You have to have other counsel because that's what's in your client's best interest. They cannot usually take it from there. They have to, you have to usually have a referral process already set up in place. Finally, let's talk about fees a little bit, and then I'm going to talk about how you go about finding this stuff on the on the web. I really like the idea of fixed fees, what some people call value billing. I think there may be somewhat difference there, but very similar. Fixed fees are great from our side because once we've done something enough, like a plain vanilla mom and pop estate, there's the same forms that you file in every probate. There's the same process in every probate. It's basically we're going to sell the house, and I'll unbundle that and say, I'm not going to be involved in selling the house other than I will do the personal representative deed when the time comes. You sell it on your own. You hire a realtor. I'm not involved in that. And my fee for doing the paperwork to get you in and out of the probate court and help you get the house sold because you need the court order is blank dollars. People really appreciate that. And then at the end of that interview, I can say, and because it's a fixed fee case, you can call me anytime. You can call my staff. Any of the heirs of the estate can call me, and it doesn't run up the bill because I know the minute they walk out of that room, they have a million questions. Even though I may have answered them in the initial interview, they won't remember that. But they feel good about being able to call back a week later and say, what about this and what about that? Maybe something I've already told them doesn't cost them another fee for calling and getting that information. And then you just build that all into your pricing schedule that you figure they're going to call 2 or 3 times during the process, and you just calculate that into your fee. But they really appreciate the fact that there's a fixed fee. They know what it's going to be, and I usually tell them when I'm going to bill it so that they're not surprised when they receive the bill down the road. It's fixed fee. And there are times when you get burned on that because you sometimes probate cases take turns that you don't anticipate. But that's just the cost of doing business. Sometimes you actually don't make a great profit on those, but the other 90% of the cases where you do that, it's really good, and clients really appreciate it. Value billing, I think, is a little bit different concept. It basically says I can do this for cheaper than my normal rate because I do it more often or because I can have my paralegal do it, and you should do that. People also appreciate that you're not charging attorneys' rates for doing things that are really bookkeeping or clerical work, and you build that in and say, in a probate case, we're going to have to do this accounting. You don't want to pay me to do it. Let's pay my bookkeeper or my paralegal to do that at blank dollars an hour if you can't. That may be something you can't do a fixed rate on because you don't know what the accounting is going to get into, but at least they have the sense that you're not gouging them because you're charging them your fees for somebody else's basic work. I think that's a good idea just from a business perspective, is to treat people as you wish to be treated. I want to now talk to you about how to find this stuff. Well, there's a couple places, and they're very similar. On the CBA website, if you just Google's not the right term. If you just click in on CBA website, Modest Means Toolkit and Modest Means Successful Business Planning. Basically, they're very similar documents, and in there, when you get there, you'll find the toolkit is downloadable. If you're a CBA member, it doesn't cost you anything to download it. If you want to buy it, I think it's $45. If you want to buy a hardbound, don't know why you would need to do that. And it's very, very useful. It has chapters on how to screen your client and avoid problems up front, which I helped write that chapter. It has chapters on finances and how to keep your finances in order and make sure, law office is a business. How do you avoid getting in trouble as a business? It has a chapter on getting competent. Where do you find information about some area of law that you've never done before? There's a whole chapter on what we're talking about today on unbundling and limited scope representation. In that chapter, there's the JDF forms that you need. There's some flow charts that you can use to help clients understand how a case might flow and where you could get in and out. The toolkit on Modest Means has a chapter on marketing. How do you let people know that you're available? And I think it's a great idea to market and say, we have this service. We do, our powers of attorney cost blank dollars. Our standard husband and wife will cost blank dollars. So people know when they come in. I think people tend to think that lawyers are more expensive than we really are because they've heard all the horror stories. but in a small town especially, the word will get out quickly, and the people that are overcharging won't get clients coming back. And I think it's a good idea to market and say, this is what it's going to cost you. There's a chapter on technology, how to use computers and other things to make it easier to do your practice. A chapter on office space, chapter on staffing, chapter on insurance and professional liability. There's a whole chapter on ethical issues and representing modest means clients. Basically the same talk that Adam just had, only it's specific, it's more broader than just unbundling. And then there's an appendix that's the CBA lending library. It tells you how to find lots of good stuff. So do use the Modest Means Task Force Toolkit. The task force spent a lot of time and energy, a lot of good work from, I don't know, 20 or 40 people to put together this information, and it's all designed to help attorneys be successful in representing moderate income clients. I'm circling back now to what I first talked about, and that is that there is a gap in the middle. Indigent folk can get some help sometimes from Colo Legal Services or from pro bono programs, not always, of course, but sometimes. And if you can pay enough, you can get anything in our society. It's the people in the middle, and as we were doing this task force, many times we heard the phrase to the attorneys, you can't afford to hire yourself. And I thought about that many times. It's how true that is, that if I had to hire an attorney at my rates, that'd be difficult. And so we're trying to bridge that gap by encouraging attorneys to take the moderate income client, treat them as every other client, but maybe unbundling is a way that you can do that and help them and get them some justice and not break the bank, not break their bank as you do that. And this whole toolkit was designed to help you do that. Wonderful tool, I think. I've read through it a couple times, and even though I've been practicing 30-some years, there are some things in here that I thought were really helpful, and some forms that I've now adopted to my use. So I encourage you to do that. There's a whole, the first chapter is about intake. There's a whole list of questions that you may have and that the client may have. And the client may have questions that they should be asking that they're not asking. Those questions are there in that toolkit, and you will impress your client if you say, you know, you didn't ask me this, but I'm going to tell you because you need to know this. And they may say, oh, well, I sure have asked that, and I didn't know to. So I encourage you to find that toolkit and use it. The other thing is the Successful Business Planning book that Adam mentioned. It has many of the same things that the toolkit has. We took stuff back and forth between the two documents. It actually has a little bit more stuff, and if you buy it, as Adam said, you'll get a CD that goes along with it that has forms and things that can be useful. So that's 45 minutes. Is that what you wanted me to do?
That's perfect, Aaron. Thank you so much. It's great information from all three of you, Adam and Aaron and Justice Hood. So thank you very much. Aaron, how do you feel about participants contacting you with any questions?
Sure, right now or later?
Maybe later.
Later's fine.
Okay.
Do you want me to share my email address now, or do you just want them to, how do you want to get that to them?
I can email it. I've got everybody else's contact. I'll send it out with some of the materials as well as the contact information if that works for you.
That's fine, and I'd be happy to talk with anybody. We're in this.
We're good now.
Robin, I just asked if we have time for questions now.
You know, we do. We have a little question window in our program. If anybody has a question, feel free to type it in. Our mute function is misbehaving a little bit, but feel free to type in any questions into the little chat section in GoToWebinar program, or you can email them to me or any of the presenters.
And don't forget to send in your notice of accreditation for 2 ethics credits.
Correct. I did email that this morning. If anybody did not receive it, let me know, and I'm happy to send it out again. I am not seeing any questions being posted at the moment, so I'll trust that everyone will contact the speakers as questions are thought of. So again, thank you to the presenters, and thank you to everybody who attended. We had a great turnout today.
Adam, did you have anything to add? We may have lost Adam. I don't see any questions coming up either, Robin.
No. All right. Well, thank you all.
Maybe we put them all to sleep.
Hopefully not. Most everybody is still here. But thanks for joining us this afternoon, and thank you to the Pro Bono Coordinators Committee whose idea it was to put this webinar on. We'll talk to you all soon.
Okay, thanks. Bye-bye.
Thanks.